Okay, we've completed our executive session. Next item of business, we're back in open session. Next item of business is was originally shown on the agenda as item 2, executive session pursuant to 4231.10.1B for real estate acquisition. Is this still a topic that we need to discuss, Mr. McPherson? If so, did you want to do it in open session?
Yeah. Probably more appropriate after discussions with Mr. Dickerson yesterday that this be conducted in open session. This is in regards to the settlement agreement with CMB Holdings. The deadline for that settlement agreement is approaching us. It is August 31st. Basically, the reversionary portion of the purchase sale agreement originally done in 2006 for that property out in the TRAC. We entered into the settlement agreement with CMB Holdings on April 8th, and we have a deadline of August 31st to initiate that agreement or it lapses, essentially.
I don't think you meant to say initiate, right? You mean to finalize that agreement?
Well, the way it reads, I think it would be initiate.
Okay. So we've had discussions, we've got a proposal or a potential agreement in place, and so we need to execute it?
Well, there's nothing that requires us to finalize.
Let me take a different tack. What specific action do you need from the board?
Whether or not they want to move forward with the settlement agreement.
And if the answer is yes, then what's the next step?
Then we work with the owners of CMB Holdings to reacquire the property.
Okay, all the terms and conditions are already established?
Correct.
Okay.
So that right now we have an option if we're going to continue on with it or not.
Correct. We have an option that we need to exercise by August 31st.
Maybe because of the latest sales, maybe something may change our mind that we may want to do something different.
There's nothing that binds us to go forward with this agreement, but we can still move forward with it if you so choose. It just gives us the option.
Okay. Well, I think the terms we've discussed in the past, especially in the light of the current sale, it makes sense for us to go forward with the proposed settlement.
I totally agree.
Well, what was the? Can we talk about that agreement in open session? What was that price?
I mean, the agreement is a public document.
Mm-hmm. Okay. So what is the price?
The agreement was for us to purchase it as something substantially less than what the property just sold for.
Yeah. What was that amount? Could you remind me?
No.
Because I was here gone day. The motion was.
I don't remember what the square foot cost was. I just remember it was substantially less than.
That's what I was going to say. Doing this sale here, if it wasn't substantially less, I wouldn't be interested. Because I think it just would be a par. I don't know if I'm still interested in that. But
So I'm going to move that we move forward with the proposed settlement as previously discussed by the board.
I have a question.
Excuse me, Mr. Beaton, you're out of order.
Okay.
There's a motion on the table. Is there a second?
There is.
Okay, we have a motion and a second to move forward with the settlement. Now is the appropriate time for discussion. I'll give the board first opportunity, and then we'll hear from Mr. Beaton. As the maker of the motion, I have first option. I think I've already said what I think is a relevant piece, that this represents a good value, I believe, for the county. Any other commissioners have anything they want to say before we move to Mr. Beaton? And we'll come back to the board if you have other comments.
I just want to make sure that it is, I want to get the numbers and make sure that it is before I vote positive on. I need to make sure we're not near. And I'm sorry, I don't remember the numbers. Before I knew we were going to come back to this. I wanted to make sure I see how this land sold and what happened with this one. So at this point, I want to get some more information.
Okay, Commissioner Cook.
No, I have no. I remember the numbers, and I think it's a good value for Franklin County. Looking at where that property lays, and those properties together is a definite benefit.
Okay, I don't remember the exact number, but I know the ballpark, and it was far less than what the land just sold for. Mr. Beaton, my apologies for cutting you off so abruptly, but I needed to keep the process going. The floor is yours.
Is this on?
Yes.
So I wanted, on this particular circumstance, I wanted to be sure that I read this statement into the record. So there's a lot of information. And let me say this.
Then Mr. Beaton, move closer to a microphone.
Okay.
Matt, if you don't mind, why don't you come sit up here so that Commissioner Cook can hear you better?
So I became aware of this sale. I've known this property's out there, and you guys know we've been working on the track, but I was down at the election center, and I saw the article. And all of you know, I have a 28-year background in real estate and appraised for much of it. So I have a particular interest in this stuff. I follow this stuff on my own. I did attend the auction as well. I spoke with two of you anyway about it. I'm sure you both recall the conversation. And so I guess the important part that I have is that I have concerns that the settlement agreement that you guys approved on April 8th regarding the exercise of that reversionary clause may be a gift of public funds. There's several elements that are needed to alleviate that concern. For starters, I realize all of us have a sense of value and things like that, but in cases of expending public funds, I believe and I would assert we need a private sector objective market-based appraisal of the property. And furthermore, an open public discussion on the public purpose of the purchase. And let me say what I mean by that, because I understand what you guys are talking about. You've mentioned some of it. And so what happened when that recent auction came up, I was interested, I attended it. And in the last couple of days, I've been trying to unwind why sell those properties now? What are we going to do with the money? And then how do we value all of this? So I was aware of what's going on out there, but I really hadn't followed it very closely. I missed a few of the meetings that I wasn't able to listen to or I was out of town. Needless to say, as I tried to go back and use the public record, it was instructive. I could not, using the public records available, figure out how you guys arrived at the purchase price. And furthermore, I couldn't figure out from the public record why you were exercising the reversionary clause. And so one of the reasons I bring that up is I wanted to alert the board to a condition that would be hard for you to know, quite frankly, and that is that when someone's trying to come in and use the records of our meetings, of the county's meetings, to figure out in retrospect what's going on, due to the number of executive sessions. In fact, on April 8th, you guys entered into an executive session and you came out and made 2 decisions, and and I listened to the public record and I also read the records. I couldn't tell what was going on there. And so, we just sold property for close to $1 million. The settlement agreement lists a price of $580. I've got it here somewhere. Needless to say, it lists a price that when I tried to find the documents that support how we arrived at that as a county, and in light of the fact that we just sold property, this is the appraiser coming out of me and an investor. You sell property to purchase property. It raises questions. So I'll keep the appraiser out of it and stay right with the auditor piece. And the auditor piece is, I think we have an obligation to the public to explain or at least show why that's a good value and not necessarily a hip pocket valuation or a sense of what the market is. So I would ask that maybe those documents exist and maybe they, I just wasn't able to discover them in the last 4 days. I haven't been able to put my hands on some of the key pieces of information that came out of it, but I do have some of the draft copies. And so anyway, that's what I was able to glean out of the system. So, but that's why I'm here today, is because I think, like I said, you guys, there's no way you could know this unless you were unless you tried to do it somewhere else, tried to figure out what another board was doing, needless to say, the public, you're likely unaware that condition exists. That is, that it appears as though it's not transparent and open, and I know that's not the case here. So I think it might be worth reviewing the way we present this information, and also that's an aside from this actual. So I hope you'll take that into consideration when you vote, that to take $500 and close to $40,000 of the $900,000 and repurchase it for the purposes of combining it, unless you have, in appraising, you can do a prospective appraisal. And a commercial appraiser will lay out the prospective value of your proposed transition. Until we have that, I don't recommend going forward.
So, Mr. Beaton, I'm going to speak to a few of those things. I'll take it on face value that your sole purpose in being here today is to look out for the best interests of the citizens. I've always known that to be your approach in the past, and I don't think it's any different today. But I will point out that the questions of, why are you selling and selling now, and what are you going to do with the money, are really the purview of the board, not the auditor. If there's some concern about the value, I think it probably is wise that the board look at some sort of an appraisal. In this case, I think the details that you're hoping to be in the public could and should be in the public upon execution. The reason that they're not out in the public now is because the board has been engaged in negotiations for the exchange of properties and money, and that those kinds of negotiations, the state has determined, are appropriate for executive session, and that you don't roll those out into the public record for fear of corrupting that process or putting the county and its citizens at a disadvantage. If the board feels that a prospective appraisal is necessary in this case, then I can see some wisdom in doing that. I think there's going to be a cost to us, where the acquisition that we're looking at now, I think if I remember right, puts it, does anybody recall the exact dollar amount in the square footage, Bob?
850? I don't remember.
In any case, the discussions that the board has had, and I can't, because they're executive sessions, can't go into too much detail, but there was certainly a feeling that, and let me rephrase that too, I don't want to get into executive session discussion. To execute the reversionary clause that was in the previous sale agreement would not be without cost or risk to the county. And that, combined with what appears to be a favorable square foot value for the acquisition, gives me to believe that this is clearly in the best interest of the citizens of the county. Now, if the board feels, or based on the auditor's recommendation, feels that we need more assurance of that and we want to spend the money to do an appraisal, I'll happily support that as well. But I think the point that I heard was that there isn't enough of this discussion in the public record for people to know here today exactly what the terms and conditions and motivations are, and I don't think that's improper or unusual. There's a reason that we do these discussions in executive session. I want to go back to my initial comment about I don't know that it's auditor's purview to focus on what the board intends to do with the proceeds from this or any other land sale, and why we're selling or why we're selling now, unless the auditor thinks that there's some nefarious intent, in which case he should say so. But I have spoken to this in the past, which is the county has certain real property holdings today that are valuable and likely will have need of real property in the future that we don't control now. And that it might be wise for us to liquidate some of the resources, real property that we have today, and create a liquid cash account so that if and when highly desirable properties that the county really does need come available, we're in a position to purchase those without bonding or adding additional taxes on the citizens. So this is a strategic maneuver to do a more comprehensive financial approach to being able to secure important properties in the future. I've always been a little reticent to put too much meat on those bones, because if you've got your eye on particular pieces of property that the county might really desire for its future, you don't want to telegraph that either. So perhaps that contributes to a perception that we've not spoken in great detail as to exactly what we want to do with proceeds of the sale. So I hope that adds some clarity to where we're at.
I'll follow that up with a couple things. So, I mean, my perception as the elected auditor is that the public relies on us to not only work together, but to also be a check and balance for each other. And my question would be, is it possible if the county were to inadvertently pay too much for something, who should catch that? And not only as an elected official, but how about as a citizen? I mean, we stand ready, the county does, to expend money, and I'll step down from here and ask as a citizen. I've sat for years. One of the reasons I ran for office was not being able to understand some of the decisions that were being made and the logic that was used to arrive at them. So at the end of the day, I guess I would respectfully disagree with the notion that I shouldn't ask the questions I'm asking, because in fact, to know not only what's going on, but why it's going on, and for the citizens to be able to tell in retrospect.
Mr. Beaton, the key there is in retrospect, and as I said, if the board takes an action, all this is public record, and the public does have the opportunity to see the detail, to know what was purchased, to know what was paid for it, to know what we paid for it, and the reasons why we did it. To go into that detail in the middle of the process puts the county potentially at a disadvantage in negotiations. That's the very reason that we have the executive session. So I want to make clear, I'm not saying that your concern isn't well-founded. It may just not be properly timed. Now, if you do think that there is some inappropriate action by the board, then I think all three members of the board would invite you to bring that to our attention whenever, because I don't think anyone on the board, no one on the board has those kinds of intentions. So I'll just go back to, it's not a surprise that executive sessions that are authorized by state law to allow us to negotiate in good faith without disadvantaging the citizen's position don't contain all the detail you'd like to see, but that will be available upon conclusion of the proposal or the agreement, the settlement. That's the term I was looking for. And if at that point there's something that's not in the best interest of the citizens will cure that at the voting booth.
And I brought up the executive session only to bring up the part that my knowledge on this was limited by what I was able to find in the public record. So, sure. So you're right. The executive session bump up against the sunshine laws, and that's why it's very difficult if you get too many of those. All I was pointing out there was it would be hard for you to be aware of what I was pointing out with regard to what I had found and how I had found it. At the end of the day, I guess my last statement on it's this. If I own the TRAC and I own these properties, I would, as an individual, and I believe that's what I have to bring as an elected official, would I go ahead and sell 3 parcels and purchase another one on a reversionary clause? Would I do what's going on or what I was able to perceive as going on? Would I do that with my own money? And the answer for me personally as auditor and as someone who I believe in the room and can influence the discussion for you guys to consider, to think about when you're making these decisions, is would I go ahead and sell 3 parcels and buy 3 more without some kind of expert certainty that I was personally expending money and this would work out? And the answer for me is I certainly would not. If there was a buyer for this property and we needed to revert it in order to, and so this is my thought process behind why I said, well, let's make sure, because if that appraisal's in place and that all makes sense, man, it may well be. You obviously arrived at a sales price, and I'm sure through further digging we'll be able to find out.
Where do you get the numbers for an appraisal, man?
What do you mean?
If you've been an appraiser, where do you get the numbers to appraise that property at? Local sales, don't you?
Well, that depends, actually, Bob. It depends on the market. That's another thing is that when you notice the sale we just made was, I think it was purchased from a gentleman out of the area, and there were several people that were not in the area, from the area. So when you value, go ahead.
What I'm getting at is the numbers that an appraiser is going to come up with if we spend the $5,000 or whatever to get an appraiser. Our property we just sold was like $11 a foot. The property for my place was like $9.60, almost $10 a foot. And this property that we're working with is considerably less. So I can't follow your appraiser thought at all.
Sure. Well, let me give you the rest of it. This is all for free. It comes with the deal. So here's what it is. The question is that I would ask in this discussion, why is the property reverting? The property is reverting because it was purchased, and he can't see he doesn't want to develop it for where it's at. And I believe,
Mr. Beaton, you're now making assumptions that I don't think are warranted.
okay, let me say this. I can infer that it's not being developed in its current state. I can infer that because it's not. And so if we're going to say, okay, it's not being, I can stop there. It's not being developed.
It's not being developed, and the purpose of the reversionary clause was to try and get it developed. But because you and I don't have direct insight as to why it's not being developed, we can't therefore make judgments about the property just simply based on the fact that it's not being developed. For example, we can't assume that there's some problem with the property and that's why it's not being developed, because for as far as we know, it might be somebody that bought it and for cash flow reasons or for other reasons that we can't even imagine are on the table. So the point I'm driving to is I don't know that we can or should make inferences about value based on the fact that it hasn't been developed thus far.
I'm not making a value.
Okay.
I'm not drawing value on it. What I'm saying is whatever hands it's in, it is they're not developing it. And the question is, for whatever reason they're not. We don't have to answer that. I just know that that means there is an impact, or there is potentially, we need to eliminate whether there is one or not. And so by virtue of the fact that I think, Bob, just in this discussion, you mentioned purchasing it and combining it with something else. My point is all of these things, we're not going to solve this here. All of these details, and the difference, Bob, is I know what you were getting at about the comparables they'll use. You're right. They'll likely use, especially since this sale just occurred, one of the things I would note is that this sale occurred after you arrived at the price to purchase this, because the settlement agreement was from April. But furthermore, what they bring to it is, of course I was an appraiser, so I'm biased, I guess, a ton of professional experience and impact, and then timing of what's there, what's not there. You're paying for the professionalism, and you're getting behind that, a set of standards, as well as all of these assurances through their insurance, errors and omissions, all this stuff, that it's actionable. And it is, I don't know of anybody that doesn't have some indication or spends money out of their hip pocket unless it's, I don't know of any. So just as auditor, I feel like if I'm not the one that brings this up and asks these questions, and by the way, you can listen to everything I'm saying and you can go ahead and do what you want, but I think it's important that these considerations be on the record and that they be, that they be considered.
So, Mr. Beaton, what specific recommendation is it that you have for the board that you'd like us to consider? I don't want it to get lost in the discussion.
The two things I brought up, the most important one is the valuation. How did we arrive at the sales price? So I don't want to see the county expend, I mean, maybe you guys...
So what is the recommendation? Is it to hire an appraiser and get an opinion?
Yes.
Okay, and what was the other one?
The other one was just the idea that, that's basically it. I mean, as far, in the appraiser box, you define it to that.
Okay.
That's it. I don't want to see the county expend more, and I want to be able to, if the auditor came in and looked at this and said, you bought this, how did you arrive at the price? We should be able to show when we're expending public funds, this is how we arrived at it.
So just hypothetically, as an appraiser, if within a same area the size of a couple of football fields, you saw 3 parcels that were relatively comparable in their own right in terms of exposure and access and land quality and developability, access to infrastructure, etc., and one of those sold for a little over $9 a foot prior to discussions. Another one sold for roughly $11 a foot not long after, following our discussions. And you were offered a comparable piece that was, let's say 40% less than the $9.
Sure.
Barring knowledge of some significant defect, you might think that, at least on its face, that would probably be a reasonable thing to seriously consider, right?
No, and I'll tell you why.
All right.
The price point you arrived at was arrived at prior to those sales. So those
Sir,
are...
it was not. That's why I pointed out one sale took place before, another took place after.
Oh, okay, you're not talking about the 3 that just sold.
Correct.
Okay.
There was a parcel sold before that, correct, for, I believe, in excess of $9 a foot. We are talking here something $6?
5 or 6.
5 or 6.
Yeah, maybe.
So,
Brought to us.
Sure. I don't want to underestimate, as the auditor, when I need something done at my house, I hire someone who knows what they're doing on it. I understand it. That's why I'm here. I understand we all have been in business. We've all done this kind of thing. I just think it's important because there is the underlying conditions on the sale. There's access to the property. There's frontage foot. I can tell you right now, the paper disclosed that the 3 parcels that just sold did not have a reversionary clause.
right,
The subject parcel does. The
subject parcel does not.
well, we're attempting to revert it, is what I'm talking about. So when you value things, there is kind of intangibles, or there's conditions and covenants, there is the cost of extending sewer, there's development costs, there's all these things that we can hip pocket this, and that's why I just want to assure, in my role as auditor, I want to be able to assure the public that we are not expending more than we should. In the end, ultimately, it may prove that it was the price was excellent. Great. But I think that the process matters here, and I think assuring the public in this case is very important.
Point taken.
Okay, fair enough. I don't disagree. So there is a motion and a second to move forward with the settlement as proposed. Mr. Beaton is, I think, advising that the board should get a professional appraisal to determine the value of the property rather than trust the collective judgment of the board, recognizing that none of us are professional appraisers, and that we may be overlooking unforeseen conditions that might impact the value in ways that we're not seeing or considering. Mr. Beaton, would you say that's a fair assessment of your position?
The only thing I would add is if you have prospective use for it, to purchase it back as it is now, if there is, either Because I understand, the reason we reverted is we think we can get it developed through maybe Bob, I think you mentioned combining it. So when you look into it, you look at it as it sits now, they have an as-is and an as-proposed value. If you gave the appraiser some conditions on making, some boundary line changes. So those two values are important because if there's...
So, Mr. Beaton, those are all things that the board had considered in executive session. You're aware that the county owns the adjacent piece, I'm sure. So...
I am.
Okay.
This property was not, we didn't enforce any reversionary in the property. It was offered to us.
Correct.
Okay.
Which precludes any costs of litigation or other issues as well. So there is a motion, there is a second. We've had good discussion. We've had valuable input from Mr. Beaton. What's the pleasure of the board? Do we want to table this issue and seek an appraisal? Do we want to move forward as planned? What's your preference?
Move forward as planned.
I just wanted to get some information, before I make that, and that basically was some things we talked about there. No one recalled the price. That's all I needed. So it's just premature for me to want to make this motion. I think we have more time, don't we, to make this call.
So there's a motion, there's a second to move forward with the settlement, and looking for input as to whether we want to pause for a moment while I get. I don't think we can. Well, yeah, we can. It's not locked. People can come in. So what I'm looking for, Mr. Miller, is whether you wish to move forward with the settlement, in which case obviously you vote for the motion, or whether you would prefer that we delay for purposes of getting an appraisal on the property, or perhaps for some other reason, recognizing that we do have a deadline of, what did you say?
August 31st.
August 31st, which is about 2 weeks. I don't know, Mr. Beaton, do you think we can get a professional appraisal in that time frame?
There's not a chance.
Okay.
Well, I think I feel comfortable that the price is going to be below the appraisal. I don't know that because I'm not an appraiser, but I don't even know. I mean, I'm trying to go back what the price is, and I'm sorry for my negligence here. Does anybody remember what the price is? And do they want to say it, or we want to go into a meeting? Yes.
That's why you go into executive session for real estate acquisition, so that that particular price isn't advertised all over.
Yeah.
That's right.
And I've already spoken at length to the fact that we did all this in executive session in compliance with the law for exactly those reasons. And I understand Mr. Beaton, as the auditor, is looking out for transparency, and I know every member of the board shares his concern about that, but it's appropriate in some cases not to do these details in public. So I think you've got a sense of what the number was on a square foot basis. You know what property sold for before that. You know what it sold for after that. Right. And Mr. Beaton has more experience appraising property than anybody in this room. And I hear him when he says there may be things you haven't considered. You might not have thought about access, or you might not have thought about where the city utilities are. You might not have thought about visibility, or whether it's more or less valuable when connected with other property. You might not have thought about the development history in the area and whether it's on the uptick or the downhill. You might not have thought about a whole bunch of things. But each of us has to make a decision whether or not we feel comfortable making a decision based on what we do know.
Well, I think if I remember, it was a good bargain. It was a good deal. I mean, it was under any appraisal we had before, and I think that's why it was thought upon to do this. So, with the prices, I don't have the issue. I don't have a problem with that. Is there anything else that you were?
Well, let me ask, Jared, do you have a sense of where we are if we don't execute this agreement by the end of August? And Mr. Beaton, do you have a sense of how long it would take to get an appraisal?
I've been out of appraising for 5 years, so, and that would be a commercial sector appraisal. The one question I would have,
Well, no, if I may, I need to keep us on track here. Do you think that we could get an appraisal in 60 days? Or do you not know? I understand, I don't know.
I think the most important piece of this is not necessarily that timing, but it's the fact that we are able to show the valuation.
Well, I appreciate
So
that.
I couldn't
Excuse
answer.
me, Mr. Beaton, I appreciate that, but the point I'm trying to get to is we've got a tentative agreement in place. There are consequences potentially to the county if we don't execute it on time. So knowing what that window is of when we might be able to get an appraisal allows us to weigh the risk of extending versus the likelihood of being able to get the appraisal. That's where I'm going. So I suppose by mutual agreement, we might be able to extend it?
Well, knowing what the recent sales were, just last week,
I would,
we may not agree to it.
I would, yeah, okay.
I guess, one last point. What's that?
Go ahead, Bob.
Call the question.
Okay, question has been called, which is a motion to end discussion on a topic, and there is no other discussion for this motion, so all in favor of ending discussion, please say aye.
Aye.
Aye, okay. So discussion is ended. There is a motion and a second before us to move forward with the proposed settlement agreement for the property as previously described by Mr. McPherson. There is no more discussion. All in favor, please say aye.
Aye.
I gotta think about this one. I know what my personal feelings are on this. If it was my business, what I would do. But I do think there's got to be probably some merit to how we handle this. And I'm afraid the process might be that we need the appraisal. However, I can tell you that that price is reasonable. But I'm not the appraiser. So
Well,
I'm going to abstain from this. In fact, I'm going to disagree at this point. I'd like to see an appraisal. And the only way we're going to be able to do that is to further talk. Isn't that correct? With Mr. Messer and extend this.
We'll basically lose our window of time at the agreed price, no matter what the appraisal comes back at.
Well, let me do this. Can we bring this motion next week? Any problem with bringing the motion this week?
as I understand the rules, Mr. Miller, you'd be within your rights to move to table the topic, but you'd have to have the consent of the motioner, Commissioner Cook, to rescind his motion as presently before us.
Well, I'd like to ask that because I mean, we got before the end of the month, so we have no harm. I'd like to ask that we table until next week.
So, Commissioner Cook, that would require your concurrence in you rescinding your motion that's currently before us.
I am not going to rescind.
Okay, so the motion for the table dies. So, while I acknowledge that it's perhaps a bit irregular, I believe it to be lawful, and Tim, weigh in if you know otherwise, for me to exercise authority as the chair to suspend the voting, take us into executive session for purposes of discussion under 4230-110-1B regarding real estate acquisition and site selection, to ensure that all the board members have current information before proceeding with the vote. And with that, we'll be in executive session from 10:44 roughly for up to 15 minutes. And Commissioner Miller, we're going to need you for this executive session at